Thank you so much, Congressman Steve
Thanks,
Scalise.
Dana. Great being with you.
All right. The House Judiciary Committee resuming its hearing with Attorney General Jeff Sessions. Let's listen.
In this response, it is stated in this response that it is the Attorney General and the Deputy Attorney General that make a decision. So are you saying that it is the Attorney General, it is your decision that is dispositive on those matters?
Yes, unless there's a conflict or that I would make the decision, yes. But he would report to both offices.
Do you see such a conflict as we sit here now?
Well, some of the matters could implicate matters that Mr. Mueller has, for example, that I have recused myself from. Other matters.
Let's go, other than the matters that Mr. Mueller is dealing with, are there any other matters that you would see a circumstance where the issue has been raised in Chairman Goodlatte's letter where you would anticipate a recusal on your part?
I won't prejudge that, but it's possible.
Do you have the authority today, subject to your recusal, to appoint a special counsel to investigate the Uranium One matter?
I believe I do.
Do you have the authority to appoint a special counsel to investigate the Fusion GPS dossier?
I don't believe that I should be talking about and evaluating cases here today.
I'm not asking you to evaluate.
Well, you basically
I'm asking you to evaluate your authority to appoint a special counsel. Not that I don't want to know anything about the investigations. I don't even want to know if the investigations are happening or not happening.
So if I'm not recused, I have the authority, yes, and the duty and the responsibility to make that decision.
Okay. As it relates to Loretta Lynch using the pseudonym Elizabeth Carlisle, are you recused on that matter?
I don't think so. And
are you recused on the Fusion GPS matter?
There I go. I'm not able to comment about that, but I would say in defense of Attorney General Lynch, I use the same, I have a pseudonym also. I understand all cabinet officials do, and maybe some sub-cabinet officials do.
Well,
so she would probably have been following the advice of the Department of Justice. I'm just saying.
That's fine.
We have to be careful.
I'm no longer interested in that. So I just want to be clear that as it relates to the Uranium One matter, you do believe you have the authority to appoint a special counsel, and you do not believe that authority that you have is subject to any recusal at this time.
I cannot say that.
Time of the gentleman has expired. The chair recognizes the gentleman from California, Mr. Liu.
Thank you, Mr. Chair. Hello, Mr. Sessions.
Yes.
Donald Trump has asked various individuals to pledge an oath of loyalty to him. Did Donald Trump ever ask you to pledge an oath of loyalty to him?
No.
If Donald Trump were to ask you to pledge loyalty to him or to take such an oath, would you do so?
Well, I don't know what a pledge of a loyalty oath is. We all owe loyalty to our supervisors. I've always done that to my bosses and supervisors. So, you know, people are expected to be loyal to their executive branch head. But if you're talking about some sort of improper loyalty oath that goes beyond a commitment to
Thank you, Mr. Sessions. Let's
following the law, I have not.
Thank you, Mr. Sessions. Reclaim my time. Let's talk about your contacts with a foreign power. So last year, how many interactions did you have with Russian government official Sergei Kislyak? I just need a number. Is it 3?
Well, of all foreign officials or just?
Russian government official, Ambassador Sergei Kislyak, last year, how many interactions did you have with him?
I spoke at the Republican convention. I came off the platform and people were there and we chatted a moment, had an encounter. Couple of months later, I believe in September, he asked for a meeting and I provided that. I met with over approximately 25 ambassadors last year, and I had that same day as, well, excuse me.
Thank you, Mr. Sessions. Thank you.
Well,
as Attorney General, you have a security clearance, correct?
Yes.
And to get that security clearance, you submitted a security clearance application, also known as an SF-86 form, correct?
That's correct.
I submitted such a form when I served on active duty in the U.S. Air Force. And the form requires you to certify under penalty of perjury that the information submitted was true, complete, and correct to the best of your knowledge. you certified your security clearance form, correct?
That is correct.
I'm going to, on the video screen, show you a question from that form, and it says, have you or any of your immediate family in the past 7 years had any contact with a foreign government, its establishment, such as embassy, consulate, agency, military service, intelligence, or security service, etc., or as representatives, whether inside or outside the U.S.? The answer that you gave was no. What you just told us under oath was exactly the opposite. So I'm going to ask you, Mr. Sessions, were you lying then when you filled out the form, or are you lying now?
What I was told by my executive assistant when we did this form earlier, and then again when I was nominated for Attorney General, that the FBI authority says members of Congress and effectively government officials meeting people on an official basis, you were not required to list all these contacts.
Nothing in that question says you get to answer any differently because you're a U.S. Senator rather than, say, a young police officer. Isn't that right?
Well,
nothing in that question authorizes you to answer any differently. Isn't that right?
I would say that nobody at the FBI or any other place, to my knowledge, said you left that blank. Surely you've met with some foreign officials in the last 7 years. I've not had any private business dealings or any things of that nature. My contacts would be in the normal course of
let me ask you
senatorial business.
Let me ask you one of your interactions.
So I thought that was a reasonable answer.
You said under oath today that you had a meeting with Ambassador Kislyak of under an hour. That's pretty long. Was it more than 50 minutes?
I doubt it was 50 minutes, but 45? It may have been 45, 50 minutes.
All right. Did you discuss campaign-related items such as Ukraine with the ambassador?
Well, that's not campaign related.
All right. I'm going to ask you two simple questions.
Yes, we did talk about Ukraine. We actually had an argument about the Ukraine because the day before, the Ukrainian ambassador was in my office making his case against Russia, and I raised those issues with Mr. Kislyak, and he was, as I referred to it, I think, the classic, we did nothing wrong.
I'm glad you're very animated.
Did everything wrong. That was his
Let me
case.
ask you two simple questions, because in a sense you've already answered it. You did have communications with the Russians last year, isn't that right?
Repeat that.
You did have communications with the Russians last year, isn't that right? Just yes or no?
I had a meeting with the Russian ambassador, yes.
Great. That's exactly the opposite answer you gave under oath to U.S. Senate. So again, either you're lying to U.S. Senate or you're lying to U.S. House of Representatives.
Well, that's
the time of the gentleman has expired. The witness can answer any further if he chooses to.
I won't repeat it, Mr. Chairman, but I hope the congressman knows, and I hope all of you know, that my answer to that question, I did not meet with the Russians, was explicitly responding to the shocking suggestion that I, as a surrogate, was meeting on a continuing basis with Russian officials, and the implication was to impact the campaign in some sort of nefarious way. And all I did was meet in my office with the ambassador, which we didn't discuss anything like that. So I just want to say I appreciate the congressman's right. I guess he can say it's free speech. He can't be sued here. And so that's just my response, and I'm sorry that that's my response.
The chair recognizes the gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, and Mr. Attorney General, thank you for your service to this country. Thank you for being here today. Much has been said in recent months about the aggressive agendas of hostile foreign actors to undermine our nation's democratic processes. We've talked a lot about it today. The American people are rightfully concerned about these subversive efforts because it seems to taint our public policy and our elections. That's at least the agenda that some have. And it's been almost 70 years since Congress first enacted the Foreign Agents Registration Act to limit and keep track of outside influences. And as you know, that law created critical disclosure requirements for any lobbying group that works on behalf of foreign interests here in the U.S., so their advocacy and activities can be properly evaluated in light of their associations. General Sessions, the question today is, as you know, the current special counsel investigation has revealed several high-profile Washington elites on both sides of the aisle, for example, Mr. Podesta, Mr. Manafort, who violated the Foreign Agents Registration Act. Would you agree that without the special investigation, these cases would likely not have become public?
Perhaps. But let me back off of that to say I really have not followed that closely, and I do not have privy to the information, and it would be inappropriate really for me to express an opinion.
I accept that. The point is that a lot of these things have stayed below the radar because there's not been appropriate focus and attention on it, and the special investigation has brought that. And in the view of many of us, it's long overdue. There's historical evidence going back as far as the administration of George H.W. Bush, highlighting failed attempts to reform the law in this area. And this is despite repeated recommendations to develop a strategy integrated with the DOJ's overall national security efforts and similar calls for higher means of enforcement. But there's been no substantive action by any Congress over all that time, and there's been a sharp decline, a corresponding decline in compliance over the last 2 decades. So clearly, everybody can agree much has changed in the world since the FARA law first was enacted in 1938. Question is, would you agree to work with us, me, and this committee to correct these very serious problems so we can update our disclosure laws so that the American people can see what's going on behind the veil?
I would. I believe our professional staff who've been at this for some time have communicated with some senators who've got ideas, and I probably have communicated with you, and I would be glad to continue that.
You have, and we appreciate it. Senator.
We have taken some action. I think it's only 7 cases in what? Years? Decades?
Yes, in decades.
So we brought one enforcement action against RT, Russian TV, I guess it is.
Right.
In effect, some part of that. And so it's a matter worth serious consideration. I thank you for giving it that.
Yes, sir. Senator Grassley and I have filed companion bills to clear up the ambiguities in the existing law and allow DOJ more oversight, so we do appreciate your attention. Another issue, on September 5th, I led a letter to your office with 17 other members from Louisiana and Texas requesting a thorough investigation of Planned Parenthood Gulf Coast actions, harvesting, transferring fetal tissue for financial gain. And I would ask, Mr. Chairman, for unanimous consent to enter a copy of that letter into the record.
Without objection, be made a part of the record.
Specifically, we requested that your office look into the congressional findings of the Select Investigative Panel on Infant Lives from last year. The panel stated that this was just one of 15 criminal and regulatory referrals made to various state and federal agencies, 4 of which were referred to the Justice Department. So the question is, do you have any updates on that today, on those issues or our request? And if not, could we get one of those soon?
I will review the letter. I do not have it at the top of my head, I'm sorry to say, but we'll look at it. And I believe the Congress, Mr. Chairman, and members here are entitled to a prompt response from the Attorney General and the Department of Justice. We've already reduced a backlog of some 400 letters by half. And we're going to, when the dust settles on our time here, I think you'll see we far were more responsive than you've had in the past. Because I was in your shoes, and I had, as Chairman Grassley reminded me, letters that I had had pending for a long time not answered. So.
Fair enough, and I know you've been busy. Third issue, I'm almost out of time, but October 12th, you made remarks to the Executive Office for Immigration Review, and you stated how the immigration court system is being gained in many ways. Today, you mentioned again about the credible fear process being abused. Is it your belief that Congress should act to enhance the credible fear standard? And if we do that, what impact would it have on fraudulent and dilatory claims filed in immigration courts? It
could have a very significant impact. We have about 90% of the people who make those claims are referred for some sort of hearing. Many of those are quickly determined not to be substantial. I remember when the bill passed, and I remember an experienced senator, I'll say Senator John Kyle of Arizona, he said, this is a huge thing. You don't know how big this is going to turn out to be. And it took a number of years, but it certainly proved to be, his prediction proved to be correct. We did not need to do that then, and we ought to go by, we need to curtail it.
We filed some legislation.
I believe Chairman Goodlatte's proposals will fix some of that.
We're working on that. Appreciate your time, and I yield back.
Thank you.
Chair, thanks, gentlemen. Chair recognizes the gentleman from Maryland, Mr. Raskin, for 5 minutes.
Thank you, Mr. Chair. Mr. Attorney General, President Trump has called the press the enemy of the people, although I think the founders probably thought that a free press was the people's best friend. As Attorney General, will you commit not to prosecute investigative journalists for maintaining the confidentiality of their professional sources?
I will commit to respecting the role of the press and conducting my office in a way that respects that and the rules within the Department of Justice.
But nothing specific.
We have not had a conflict in my term in office yet with the press, but there's some things that press seems to think they have an absolute right to. They do not have an absolute right.
Thank you much. Does your May 10th, 2017 memorandum instructing federal prosecutors to seek the most serious possible charges for criminal defendants and the longest possible sentences extend to defendants who are charged by special counsel Mueller, like Paul Manafort, Rick Gates, George Papadopoulos, and so on?
I would think so. I haven't given that much thought. I would say it does not call for the most maximum sentence. It simply calls for charging the crime, the most serious crime, and
with the highest sentence,
minimum sentence for that most serious crime.
Gotcha. I was confused about one thing that came up in the various questioning about the meetings with Mr. Papadopoulos. At one point, I heard you to say that you told him essentially, no, don't go. You tried to shut it down, the trip. At another point, I thought I heard you to say, don't represent yourself as speaking for the campaign. And I'm just wondering whether you could clarify that. Were you telling him not to go or just not to go and officially speak for the Trump campaign?
I have no specific. I remember the pushback. I remember that he suggested an ability to negotiate with Russians or others, and I thought he had no ability, or it would not be appropriate for him to do so. And I was pretty clear about that he shouldn't be pretending to represent.
And were you equally clear with Mr. Gates at the June meeting, not to go to Russia and not to represent the campaign? Or Mr. Page, rather.
Mr. Page?
Mr. Page, yeah.
Let me tell you what he says. I don't recall it. He says he was in the dinner, and as he walked out, he told me, I'm going to Russia, that I made no response whatsoever. He said it looked like he went one ear and out the other, and that he did nothing improper when he went to Russia. So I don't know what he did and have no knowledge of it. He didn't report to me and didn't act for me. And so far as I know, he didn't act for the campaign.
Fair enough. You've taken the position that members of Congress have no standing to sue in federal court to challenge President Trump's continuing receipt of foreign government payments at the Trump Hotel, the Trump Tower, the Trump golf courses, and so on. As Attorney General, our leading law enforcement official, what is the appropriate constitutional remedy for a president who collects foreign emoluments without obtaining congressional permission to do so? As a matter of law, what is the appropriate remedy?
I would have to take a look at that. I'm not prepared to give you an answer. People have
Well, you've taken the position that we don't have any standing to raise it in court. So I guess in taking that position that we don't have standing to raise it, what is the appropriate constitutional remedy? This was very serious business for the founders of the country who didn't want the president compromised by foreign government payoffs and by the intervention of foreign government. So what do we do?
The Emoluments Clause has not been a subject of a great deal of litigation. The Department of Justice has long-standing rules about standing and raised the defense of standing against Congress, against private parties, against groups, and it's pretty well established law. I'd have to get you information.
Would you clarify that for us? Thank you. So as Attorney General, you said you'd be a defender of the voting rights of the people. And America faces a number of voting rights crises today. We've got millions of people who are disenfranchised in Puerto Rico and the other territories. We have 650,000 people right here in Washington, D.C. who have no voting representation in Congress. We've got continuing voter purges and suppression at the state level. And we've got warnings from our intelligence community that there will be further attempts at cyber sabotage of our elections. What do you consider the most serious threat to our voting rights, and what are you doing about it?
Well, we will not accept suppression and illegal activities against voters. So if you have any, I'd appreciate you sending it to me.
We absolutely will.
We will make sure it's investigated by career attorneys in our Civil Rights Division.
And on the cybersecurity side, what are you doing to protect us from another hacking of our election attempt to infiltrate with political sabotage, essentially?
I believe that this is a danger, that I believe investigations have been ongoing and it's being considered. But Congressman, I have to say I'm not up to date on the latest of that, and I would be pleased to try to get you something in writing as to what we need to do, or at least what we are doing and what we may need to do to protect the integrity of our elections.
Thank you. I yield back, Mr. Chairman.
The chair recognizes the gentleman from Arizona, Mr. Biggs, for 5 minutes. Please turn on your microphone.
In there. Thanks. Thank you, Mr. Attorney General. Appreciate you being here today. I appreciate your frank testimony. And I'm going to try to go over some ground that's been covered without plowing it too much deeper. But please help me understand, what's Rod Rosenstein's role at the department right now?
The Department of Justice has a number of key positions. The Deputy Attorney General has supervisory control responsibility for all of our investigative agencies and basically the entire department. The associate handles a part of that, and the associate reports through the deputy to the Attorney General, and the deputy, the FBI director, for example, reports through to the deputy, not directly to the Attorney General.
Okay, and so what's Andrew McCabe's responsibility and role?
I think he's classified as a #2 guy at the FBI.
Okay.
And
in their positions, for instance, when Mr. Comey's position was terminated, Mr. McCabe was acting director, I think, for a period of time until a new director was nominated. And Mr. Rosenstein's been serving with you and had served previously. Was anything done to question or vet any potential conflicts those two gentlemen might have had with things like the Mueller investigation, with Russian investigation, or anything like that?
It's a responsibility, I guess, of a person involved in an investigation to be sure that nothing they do has a conflict of interest or that should require recusal.
So I appreciate that that's an individual responsibility, but so I guess nothing formally or from the department was done to vet and say, you know, we've got this going on. There's potential questions, particularly with regard to Mr. Rosenstein, Mr. McCabe's roles all the way back to the Fusion 1 investigations and continuing on for that period of 10 years. I suppose, if I understand you correctly, there was nothing done there to formally to vet them.
I think I understand you correctly, and I think that's correct.
Okay. And I know that you've answered this, so I'm going to go very quickly with these. With regard to the Fusion GPS dossier, it's been reported widely in the media that the FBI at least paid for some portion of it or reimbursed some expenses for that document. Do you know whether that's accurate or not, accurate reporting in the media?
I do not.
And I guess it's also been widely reported in the media that the FBI at some point reviewed that dossier, particularly under Mr. Comey. So do you know if that ever occurred?
I'm not able to comment on that.
Okay. When you say you're not able to comment, that means,
well, I don't.
You may not know, or there's investigation.
I have not been involved in that investigation, and I don't even read the newspapers that closely.
Good for you, I must say. And then we had an exchange earlier today with you and the representative from Ohio, the gentleman from Ohio, Mr. Jordan, and he said, seems like this, it seems like that, it seems like this. And at the end of that, you made a comment, and I can only paraphrase because I didn't write down the exact comment. My note just says, seems like you were saying, well, that you can't base a case on something that seems like something. But in essence, the very notion of probable cause indicates that something seems like something, and it seems like that person probably committed that act, which seems like it's in violation of the law. And so I guess I'm trying to get clarification of that.
This Congress has a right to ask for information, and has a right to express its opinion about whether a special counsel should be appointed, but it's my responsibility to evaluate it. And I would have to feel, or in some cases the deputy would have to feel, that there are the kind of circumstances that would justify. And we just have to know that, I want you all to know, that if a special counsel is required, I, or I'm sure anyone else in the department would, that had the responsibility, would name one. If not, we have to say it is not required. I would say that our department, with Chris Wray at the FBI and our team at the Department of Justice, I feel like we can do work, but there are some cases that get so significant and have such a level that becomes a public interest question that has to be evaluated. So I have no prejudgment, and
sure.
The reason I hope you'll give me, the chairman might have to give you a second. I did not mean to suggest I was taking a side one way or the other on that subject. I was simply responding that we would have to have full and effective and detailed factual evaluation before we make a decision on whether or not a special counsel is required. And I take no, I'm not, I have made no prejudgment.
And I appreciate that, but I guess what I'm getting at in particular is that so even with the idea that many people are questioning the impartiality of Mr. Rosenstein, who would be ostensibly in line to help make that decision on special counsel?
I'm not aware that he has a problem in that regard, but if so, we have senior counsels in the department who would give advice on that. So, and we all have to be sure that we're not crossing that line.
Thank you. Thank you, Mr. Chairman, for indulging me.
The chair recognizes the gentlewoman from Washington, Ms. Jayapal, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being with us. I'd like to go back to some of your testimony on contacts with Russia. At the beginning in your opening statement, you said, "My testimony has not changed." Later, in response to some questions, you said, "I do now recall." And Mr. Attorney General, with all due respect, it's difficult to take your assurances under oath when you seem to change your testimony each time new evidence emerges. And specifically, you denied contact with Russians under oath during your confirmation hearings. That was revealed to be untrue given multiple meetings with an ambassador. Later, you refined your response to more narrowly focus on discussion of campaign-related matters, but you denied that campaign surrogates communicated with Russian agents. That was revealed to be untrue given the sworn statement offered by George Papadopoulos. You later again refined your answer, saying that you didn't remember Papadopoulos raising the issue in the March 2016 meeting, but once you remembered the meeting, you then remembered telling Papadopoulos to cease those conversations. You say that you cannot be expected to remember the details of what happened a year ago, but you are in fact a very seasoned prosecutor and a 20-year member of the United States Senate, United States Congress, who is presumably capable of mind and memory. So, Attorney General Sessions, did you as a prosecutor accept a defense of lack of recall?
Well, absolutely, people have a lack of recall.
Thank you.
We're in an environment that we were operating in with so much happening and meetings occurring. You assume a lot of matters that aren't accurate.
Thank you, Mr. Sessions. Would you instruct the attorneys who work for you at the Department of Justice to take at face value a defense of "I don't recall"?
If a person says they don't recall and has a justified reason for it, I certainly do.
And that was not the case in the situation of the police officer that Mr. Jeffries referred to. Let me move on to another matter. On November 11th, President Trump not only trusted the word of Vladimir Putin over the brave men and women who serve in our intelligence community, he proceeded to trash the reputations of its leaders. And I quote here, he said, "Give me a break, they are political hacks." The president went on to say that he believes Vladimir Putin when Putin says he absolutely did not meddle in our elections. Mr. Sessions, do you consider the leaders of our intelligence community, past and present, as political hacks?
I would say to you, the president speaks his mind as he chooses.
Is that a yes?
He also says he accepts their position.
I'm not asking about the president,
I'm not giving a yes or no. I've given you my answer.
So you have no opinion on whether they're political hacks or not?
I'm saying to you, I respect and value our intelligence community.
Great, that's good to hear. And when President Trump said that he believes Vladimir Putin when Putin says he absolutely did not meddle in our election, help me refresh my memory. In January of this year, was it the unanimous opinion of our intelligence community that the Russian government did in fact meddle in our election?
I believe an opinion was expressed.
That was a yes?
I'm not aware of any dissent from that.
Okay, and to your knowledge, in the months since, has the intelligence community in any way changed its conclusion?
I'm not aware of it.
And on October 18th, when testifying before the Senate Judiciary Committee, Senator Sasse asked you if the department had taken adequate action to prevent election meddling in the future. You just said in response to some questions that you do believe this is a danger. Have you requested a review of what laws need to be updated in order to protect our elections from foreign interference?
I have not, and would be pleased to work with you to deal with the deficiencies we have.
That's great.
Congress would have to deal with that, not have to pass the laws.
You would want to appoint a special counsel on that issue?
Maybe I misunderstood your question. What special counsel? I thought you was asking, should we have laws, new laws, to deal with?
Well, I'm asking if you're going to investigate what has happened with the meddling in our elections.
Well, that's part of the special prosecutor.
Great.
It's not. I'm not participating in that. He has
Let me move on to
for
Mr. Miller, because I just have a few seconds here. Considering your prominent role in the Trump campaign, did you work closely with and communicate with Stephen Miller when he worked on the campaign?
I worked with him. He'd worked with me previously.
Thank you. And did Mr. Miller tell you that he was working on a letter with President Trump, which detailed the president's reasons for firing then FBI Director Comey?
Mr. Miller is a high government official close to the President of the United States, and I'm not at liberty to reveal the nature of any conversations we may have had.
Are you claiming executive privilege?
I'm not claiming executive privilege.
So I'm
following the long-established policies of the Department of Justice.
The president has not invoked executive privilege, and so I understand you're
Time of the gentlewoman has expired.
to answer the question.
Point of parliamentary inquiry, Mr. Chairman.
The gentleman will state his parliamentary inquiry.
Is there authority in this committee to permit a witness to refuse to answer a question without properly invoking a privilege? And if not, what is the appropriate response from the chairman to enforce the committee's ability to do proper oversight?
The chair recognizes that senior officials from both administrations, the current and past, and long standing before that, have long stated their ability to not answer questions regarding communications at the highest level of our government.
Well, Mr. Chairman, if I may be heard, I do not believe there is any such privilege or any right to assert a refusal to answer a question simply because
the gentleman is not stating a parliamentary
I'm asking the chairman to rule so we can appeal the ruling of the chair. If you're going to prevent us from getting answers to these questions.
There is no ruling of the chair. Well,
then I would ask that the witness be directed to answer the gentlelady from Washington's questions.
That is not a parliamentary inquiry. The gentlewoman from Georgia, Ms. Handel, is recognized for 5 minutes.
Thank you, Mr. Chairman. And thank you, Attorney General Sessions, for being here. And I want to say a special thank you to Mrs. Sessions for being here as well, and for, frankly, your patience and commitment through the many chapters of the General Sessions' distinguished career. So thank you.
Thank you for those comments.
I wanted to ask a pretty direct question, because there's been so much said here today about Russia and what you've testified to and not testified to, and a great deal of parsing of words, along with what I would call not so veiled comments that frankly are an attempt to impugn your candor, your integrity, and your reputation. So I will ask very bluntly, have you ever deliberately lied or sought to deliberately mislead the United States Senate or this body here today?
No, I have not.
Thank you. Let the record show that it was a direct yes or no on that, and it was an emphatic no. I want to ask about civil asset forfeiture program. As you know, under your leadership, the program was reinstated back in July, and you started some additional practices there. In March, the Inspector General had a report and offered several different suggestions that might be put in place, recommendations put in place for the program. Can you give an update on that? Or if you don't have it today, you can send it to me.
Well, thank you. I can. We spent considerable time evaluating the program. We recognize the concerns expressed in Congress, and I've been well aware of that, having seen it come up in the Judiciary Committee in the Senate. So we worked hard to produce a policy that had reproduced, I guess, the policy that had been in place for as much as 40 years. That only recently, in the last 3 or 4 years, 2 or 3 years, been reversed. The law enforcement community was very concerned about the reversal of the sharing and the partnership that we have established. Every federal agency and every U.S. attorney has to work closely every day with our state and local law enforcement. 85% of all law enforcement in America is state and local. And this has been one of the glues that hold that team together. So I would say that we've given. Also, when we reinstated it, I directed the appointment, which will occur soon, of an individual to be an accountability officer for the whole forfeiture process. Great, okay. To receive any complaints we get from Congress or judges or lawyers or victims that claim victimhood, and make sure we're doing it in the right way. We've shortened the time for the government to respond. We've said that we won't partner with a local law enforcement agency if they don't undergo training from the federal government to ensure they know how to handle forfeitures. And I've cautioned against seizing of homes and real estate unless people know, have clear proof.
Super, thank you. Moving to a different topic, as you probably know, there was a recent media firestorm around what was a bipartisan piece of legislation, the Ensuring Patient Access and Effective Drug Enforcement Act, a 2016 law, which, as I said, had a great bipartisanship. It raised the standard for DEA to issue immediate suspension orders against pharmacies and prescription drug distributions who might be contributed to the opioid epidemic. From your viewpoint, however, have you seen what have been the actual effects on prosecution and administrative actions around the drug distributors, and has the DEA been negatively impacted by that particular law?
First, we would use the laws we have aggressively, both as to physicians and pharmacies and also distribution companies for big pharma, and we will hold them to account. Congress will establish the laws. So this bill passed with both DEA and Department of Justice acknowledgement or acquiescence. And I'm not sure to what extent it may have had a negative impact. I would have to get back with you, make sure I'm accurate in my statements.
Thank you very much, Mr. Chairman. I yield back.
The chair recognizes the gentleman from Illinois, Mr. Snyder, for 5 minutes.
Thank you, Chairman. Thank you to the Attorney General, General Sessions, for coming here today. I wish you had been here earlier, but we're glad you're here. I appreciate your patience and giving us all the opportunity to speak very much. As I've sat listening to the hearing today, there were a number of things that I was looking to hear or better understand. First, this was, I believe, an opportunity for you to set the record straight on context between the Trump campaign and Russia. As has been noted by others, we continue to learn new evidence that demonstrates previous answers have been at best incomplete, at worst inaccurate, and I think there's still some questions around that. Second, I'm looking to understand what steps the Department of Justice is taking to protect our elections from foreign interference in the future. 2016 wasn't the first time, it won't be the last time that Russians and others will try to interfere in our elections, and we have to take steps to make sure that the integrity of our elections remains solid and that we thwart any efforts, regardless of where they're coming from foreign entities to undermine our elections. And third, I've been looking for answers on policies pursued by this Department of Justice that I believe are taking aims at the rights of Americans, from undermining voting rights to restricting LGBTQ rights to targeting immigrants. We've talked about a lot of things. I would really like to turn my attention, though, to the idea of ensuring the integrity of our elections, protecting them from foreign influence. You've been asked a couple times today, I believe, what steps you've taken since you spoke in a couple weeks ago, October 18th, in the Senate Judiciary Committee, what you were doing. Senator Sass asked you there if the department is doing enough to prevent foreign interference in our elections. Just to repeat what you said, and I'll quote, "Probably not. We're not. And the matter is so complex that for most of us, we are not able to grasp the technical dangers that are out there. These are real dangers to our elections, and our elections are the foundations of our democracy." You also said at that time, several weeks ago, it requires a real review. But today you said there is no review taking place. So my first question is, I'm very concerned. With the 2018 elections less than 1 year away, and given your acknowledgement that this is a serious, complex matter that's deserving of a real review, specifically what steps have you taken to protect our elections next year?
You raise a good point. I have not followed through to see where we are on that, and I will personally take action to do so. There are a lot of things been happening. We're working on a lot of great agenda items, but this one is important, and I acknowledge that. And I should be able to give you better information today than I am.
And I appreciate that there are many things that are important, but I would hazard to state nothing more important to our democracy than the integrity of our elections. And as the head of the Department of Justice, it's important that as a nation, as others have said, that justice remain blind, carrying the balanced scale without a finger on the scale. We need to do that, but protecting our elections is important. What steps does the department need to do to address these issues? What can we be looking forward as the next steps?
Well, one of the things that needs to be done is our states need to review their own vulnerabilities. I would say our FBI has extraordinary capabilities when it comes to hacking and those kind of issues. We probably need to work on that with them. They should have a very important role. They're highly sophisticated in that. And then our intelligence communities also, to the extent that this is driven by some foreign power, then we're dealing with potential international involvement. So all of those agencies and the states need to be involved, I would think.
And it was
Congress, I appreciate your interest, because if we need legislation, it'll take some aggressive push to get anything.
Hold that thought, I'm going to come back to that.
At least through the Senate, I know you
with
can do
another
that.
question. But you said earlier that others have touched on this, that the intelligence community has said Russia did try to interfere in our elections in 2016. Do you feel that that is still a statement of truth, or is it open for question?
I have no basis to dispute that. I do think they've said that they don't believe votes were changed.
Right. As I see I'm about to run out of time, my last question, I'll jump to the end, is to what you were just touching on. Can I ask for your commitment to provide a briefing to those of us on this committee that are interested in addressing this problem, making sure, irrespective of whether it's a Democratic or Republican state community, that we have safe, sound elections with integrity? Will you meet with us?
I would be glad to. I think that would be valuable.
With that, I yield back.
The chair recognizes the gentleman from Idaho, Mr. Labrador, for 5 minutes.
Thank you, Mr. Chairman. Attorney General Sessions, thank you for appearing before our committee today. It's always great to talk to you, and it's always great to have the opportunity to communicate. As a foundational principle of our great American experiment enshrined in our Constitution, Religious liberty ought to be protected at every turn in our nation's history under every administration. Last month, you issued a memo which focused on ensuring First Amendment protections for religious groups and individuals. The last two Congresses, Senator Lee and I, introduced the First Amendment Defense Act, which you were a co-sponsor of. As you know, this legislation ensures the fundamental right to exercise one's religion by prohibiting the federal government from denying or excluding a person from receiving a federal grant, contract, loan, license, certification, accreditation, employment, or other similar position or status based on their religious belief in marriage. Can you explain to us what inspired your October 6th memo and why you think it is important for the Department of Justice to issue such guidelines?
Well, I've cared about this for a long time, and there's a lot of work has been done. I felt that there's some abuses that have occurred pretty clearly. We've had to settle some lawsuits because the government overreached, and I would say we will what we need to understand at the most fundamental level is the First Amendment allows the free exercise of religion. It doesn't just allow you to think what you want to think, to meet in a closet somewhere and never express yourself. It allows the free exercise. And I think to a degree we've not respected that in recent years. And our opinion is based on the law. We believe it's based on the Constitution, and it's a guidance to ensure that the agencies of our government know what the fundamental principles are when they issue regulations and cite people for wrongdoing.
So what more could Congress do to protect the First Amendment and religious liberty?
Repeat that.
What more could Congress do to protect the First Amendment and religious liberty?
Thank you. We've got the religious liberty, and also in the First Amendment is speech.
Yes.
And I think it's time for us to take seriously the erosion, it seems, of the fundamental respect for the right of people to express differing views that's occurring today. We've seen it on the college campuses. We believe that free speech is a civil right, and the Department of Justice will not stand idly by if federal constitutional rights are being constricted by unwise activities limiting speech.
So just as important to me as the First Amendment is also the Fifth Amendment to our Constitution, which prohibits the government from depriving the people of their property without due process. I'm concerned that the practice of civil asset forfeiture is increasingly threatening rights guaranteed under the Fifth Amendment to every American. While forfeiture can be an important tool for law enforcement, it has been abused. Unfortunately, in Idaho and throughout the country, you have a number of cases where the practice of civil asset forfeiture has been used to improperly deprive individuals of their homes, their cash, and their property. Because of this, I have supported several pieces of legislation and floor amendments that make reforms to the federal civil asset forfeiture. In light of the mounting evidence that civil asset forfeiture is being used improperly, how do you think we can strike the proper balance between justice and making sure criminal laws are being followed and preventing harm to innocent Americans?
I know you care about that, Congressman Labrador, and other members of Congress have expressed concerns to me. I do not take them lightly. I truly believe that if there's probable cause to believe that an item of value, often for police officers, it's a stash of cash that they may catch in an automobile. If there's probable cause to believe it's connected to a drug enterprise, they have a right to seize it. Then we need to give the person who claims it a prompt and fair hearing. You can arrest a person on probable cause and put them in jail. I think it's appropriate to hold proceeds of a drug deal, at least
I think it's appropriate to hold them, but I don't think
probable cause.
I don't think it's appropriate to take them until there has been a guilty finding. In fact, Justice Thomas recently criticized the forfeiture laws, and I hope I hope we can have a longer conversation about this, because I think this is an important issue. I've always found you to be very fair in our communications, and I think we need to reform the asset forfeiture laws in the United States, and we need to make sure that people are protected. And the Fifth Amendment, to me, is just as important as the First Amendment and every other amendment of the Constitution. I think that we should work together to make sure that we strengthen it.
Some of the complaints that you've read about are state and local forfeitures and not federal. We believe our people are operating at a high standard. I'm going to have an accountability office on all of these cases, and we will not accept abuses of the law.
Thank you very much.
The chair recognizes the gentlewoman from Alabama, Ms. Roby, for 5 minutes.
Thank you, Mr. Chairman. This is so great to have you here today. We're really excited to have you, Attorney General Sessions, and we just thank you for your many years of service to the state of Alabama, and now your continued work for our nation as our Attorney General. And I've known you for a very long time, and you've served our state for a very long time, and the people of Alabama know you well. So we've heard a lot about Russia today, and things you may or may not have heard, and that somehow you're guilty of collusion with Russia. So I have two questions for you. Have you ever worked with Russians to influence an election?
No.
Have you ever, in any capacity, personally, politically, or officially, ever done anything to hurt or harm the national security of the United States of America?
I don't believe I have. I've tried to protect the national security of our country.
Thank you.
Thank you.
I want to move on to a different subject. I was pleased to see that your first act, official act after being sworn in as Attorney General, was to present President Trump an executive order to strengthen the enforcement of federal law on transnational criminal organizations. And so this is an important initiative to curtail the international trafficking of drugs, weapons, and human beings, often victims of sex trafficking, including young children. One of the reasons that I was eager when asked to join the Judiciary Committee earlier in this Congress was to work towards making a difference on this issue. And we have worked with the Department of Justice already on some very important policy changes, particularly to our criminal code, to that effect. Both the House and the Senate Judiciary Committees have held hearings regarding specifically the legal liability of websites hosting advertisements for prostitution, to include the prostitution and abuse of children. Section 230 of the Communications Decency Act shields websites such as Backpage, Craigslist, Facebook, and many others from legal liability regarding content posted by their users. So I'm interested, we had a hearing just recently on this, and I'm really interested in finding the right balance between protecting the freedom of expression and protecting the rights of these young children who are victims who are being abused without impacting the innovation of the internet. And so I would appreciate your thoughts on this issue. I know that Mr. Farenthold already asked you a question specific to the SAVE Act, but I think this is very important for us to get this right and do so working together, because at the end of the day, we have to find a solution, and we all want to do everything that we can to protect these children from these horrible, horrible abuses.
Thank you very much. I think that's a valuable thing for us to address. In recent days, I've talked about it with my staff. We haven't formed a clear picture of where we will go, but to the extent to which we could work with you on that, I would be pleased to.
Well, I do want to, and like I said, I think the most important thing here is that we get this right and strike that balance. As a member of this committee, to have this opportunity to fight for those who are unable to fight for themselves is a tremendous privilege, and I appreciate the partnership with the department on making sure that we get this right. So thank you so much. We appreciate you, and thank you for your service.
Thank you. Thank you for your excellent service to the state of Alabama.
Thank you.
No
Yield
doubt.
back.
And the United States.
The chair recognizes the gentleman from Texas, Mr. Gohmert, for 5 minutes.
All right, thank you. And Attorney General Sessions, always good to see you. And
thank you.
It's end of a short hearing, looks like, unless somebody else comes in. First of all, you know, it seemed like to me you got mistreated a little bit. There were questions about your answer to Senator Franken's question, and you know, I've got a copy of what he said. Now, he is explaining his question. He said, if there's evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do? And then we even had somebody offer into the record that Mother Jones basically said you lied. And I would submit this committee doesn't need Mother Jones to inaccurately describe or depict or tell us what happened when we can look at the conversation and see for ourselves. So let me ask you, was your meeting with the Russian diplomats, was that in the course and scope of your obligations with the campaign, or in the course and scope of your duties as a United States Senator?
Well, really, they were mostly official business.
As a U.S. Senator.
I did speak at the Republican convention, but the conversation on the floor after I finished my remarks were brief, and and then with regard to the meeting in my office, it was substantively, essentially, about foreign relations between the United States and issues
So what
like
you
the
talked
Ukraine.
about with them there at the convention, it was not about a presidential campaign of Donald Trump. It was in your capacity as a United States Senator, correct?
Well, I think so. You could say, I guess, that I was invited for other reasons, but...
Now, when you had talked before about that you had consulted with the career people about whether or not to recuse yourself, can you tell us whether or not one of those people with whom you consulted was Rod Rosenstein?
Yes, I could say how that occurred.
But did you? No, I'm just asking
I understand.
if you did.
So I was just thinking out loud whether that's a kind of consultative relationships that
I'm not asking
I should
you to reveal what was said.
I talked to another senior official in the Department of Justice who holds a position, and he also consults others within the department before he makes opinions.
Well, were you aware when you recused yourself of the investigation by the Justice Department into Yandex's email account, Schlapai2009 at Yandex RU, Google email account, marvijodel at gmail.com. Are you aware of those, the criminal complaint? No?
No.
All right. Were you aware that, and I've got a motion to seal here.
I don't think so. I'll just say it that way.
Well, yeah. Well, this was an investigation into Russia trying to corner the market with U.S. uranium. And there is actually a motion to seal. I'm sure you've filed them many times as a U.S. attorney. And this one is respectfully submitted. Rod J. Rosenstein, U.S. attorney, and Adam Akey is the assistant U.S. attorney, asking Judge William Connolly to have this Russian investigation, the investigation into the Russian effort to corner our market, to seal those records. So you were not aware that Rosenstein had this prior dealing with Russian uranium before you recused yourself, had you? You weren't aware of that, right?
Well, my recusal that we made public was for the Mueller investigation, the campaign
Right.
Russian
Well, but
interference.
Mueller was appointed, but
Right.
you weren't aware that Mueller had been central in the investigation before Jim Comey took over at the FBI September of 2013. So you were not aware of the Mueller-Comey investigation into Russian uranium, were you, before you recused yourself?
I don't think so. No, I was not, of course. I wasn't in the Department of Justice and wasn't aware of that when it was going on.
My time's run out, but we've got a chart here that shows just how integral the relationship is with Mr. Rosenstein, Mr. Mueller, into this whole Uranium One thing. It sure stinks to high heaven, and it doesn't appear to me they ought to be involved in investigating. But my time's run out, and I sure appreciate your service.
Thank you. I appreciate your service. Mr. Chairman, I would just note that the matter that was prosecuted concerning uranium or Russian business companies was 2 years after this CFIUS investigation, and that's when Mr. Rosenstein handled it. It was brought to his office. It didn't hit his office until 2 years afterwards, and it's really unrelated to the allegations about Uranium One, as I understand it.
Mr. Chairman. Gentleman from Florida, Mr. Rutherford, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, thank you very much for your service and your time here today, and I'll try to make this as short as I can. But representing and speaking for the sheriffs across the country and other chiefs of police as well, you know, one of the issues that I know that they have great concern about is through your grant process, if you could just have someone look at this situation where non-relevant criteria are placed on grants to require agencies to meet some performance criteria. For example, one that I was familiar with was NIMS compliant, National Incident Management System. Had absolutely nothing to do with the grant, but they put that on as a criteria for grant application. And what that does is it takes away home rule from local law enforcement. And I know several sheriffs and chiefs are very concerned about that. Have you had any issues with that you're aware of?
Well, the statute Congress passed for the grant program allows the Department of Justice to place special conditions on grants, but the one we placed that deals in the future with sanctuary cities is minimal. It simply requires a cooperative relationships where federal officials can go to the jail and that the people at the jail can communicate with the federal law enforcement officers. Does not require the states to go arrest people or hold them past their release date. None of those things. We think it's a very reasonable thing. May still be some conditions on those grants from previous administrations, but that's the one I think that we have added to it.
Yeah, well, I can tell you that's not the one that I'm concerned about.
Okay.
In fact, the sheriffs and chiefs that I've spoken to support that wholeheartedly. So
all right. Well, thank you. I will be glad to look at that.
But the other issue dealing with, you know, if they can force you to be NIMS compliant, they can force you to carry revolvers versus semi-automatics. You know, it just goes down a slippery slope. But more important than that, I want to talk to you briefly about the VIPER program under TSA. That's a visible intermodal prevention and response teams that work surface transportation around our rail, our buses, our subways, those sorts of things. But there was a move at one time to actually, by TSA, to actually move those VIPER operations out onto public roads and highways. And there's a lot of pushback within local law enforcement on those issues as well. Have you looked into that the legality of it, because clearly those suspicionless searches that you go through, and every air traveler in America has been through that. It's a suspicionless search that you go through at the airport, as you know, and it's based on special needs out of a Supreme Court decision that suspends the Fourth Amendment under those special needs, and that is you have a significant threat, you have a verifiable threat to public safety. And none of that exists out on those public roads. Now, if there was a specific threat, then I don't think anybody would have issue with that. However, that's never been the case. And in fact, I was told they want to do that for training purposes within TSA. And that, I think, should be unacceptable.
I have not looked at that. Of course, they're not in the Department of Justice, but we may have legal opinions that could be relevant to that. But I have not engaged in that issue, Congressman.
Right, and that's why I bring it up here today to see what is your legal opinion of those suspicionless searches by TSA without the special needs concerns out of that Supreme Court decision about significant risk and the verifiable public safety threat.
All right.
If you could look into that, I'd appreciate it.
I will ask about it. I sure will.
Thank you.
Thank you.
Mr. Chairman, I yield back.
Mr. Chairman.
I thank the gentleman. I now recognize the gentleman from New York. He has something placed in the record.
Mr. Chairman, I ask unanimous consent to place in the record an article from today's Washington Post entitled, "Has Jeff Sessions Got the World's Worst Memory or What?"
Without objection. And I understand the gentlelady from Texas has something placed in the record.
Yes, sir, and a parliamentary inquiry. I just want to put in the record January 10th, 2017, Senate Judiciary hearing on the nomination of the Attorney General, and October 18th, 2017, Senate Judiciary hearing on oversight of the Justice Department. Parliamentary inquiry is
Without objection.
Thank you. The General said a number of things that I hope we can work together on, but in particular, parliamentary inquiry to be able to put in the record and require an answer to the creation of a task force on sexual crimes against children.
I don't think that's a parliamentary objection.
But if I can put it in the record, please, and then also
that's a parliamentary objection.
I'm sorry, pardon me? And then also, the parliamentary inquiry is that we will have opportunity for questions to be put in the record, and one on the 702 reauthorization regarding sharing information with a foreign entity that interfered with the elections.
The gentlelady can submit questions for the record.
I thank the gentleman. I thank the General for his kindness. I'll yield back.
Thank you. Thank you. I now recognize myself for 5 minutes. And General Sessions, you have to know that I hold you in tremendously high regard. And I know you've had a bumpy ride, but there are some of us that really appreciate who you are. With that, as the Justice Department knows, the House and Senate have conducted investigations into the illegal sale of little body parts of little babies by some Planned Parenthood executives, as made clear via undercover videos that surfaced 2 years ago. And according to a report yesterday published in The Hill, the FBI sought documents the Senate obtained from abortion providers as a result of their investigation into the illegal sale of these little body parts. And so if the FBI has requested what is now several thousand pages of testimony and findings the Senate has gathered through their investigation into Planned Parenthood, that may mean that they could be readying indictments against individuals who have committed the sale of these little body parts for profit. So I want to ask a question that you can answer, not put you in an impossible spot, but generally speaking, are findings made by any Senate investigation, any subsequent referral, sufficient evidence for the Justice Department to bring charges upon any party guilty of violating federal law?
Well, it depends on the substance of those congressional findings, but they certainly can provide a basis for starting an investigation, to verifying the findings of the Congress, and could provide a basis for charges.
Well, I think
that's an appropriate way for us to relate to one another.
Yes, sir. Well, I hope the Justice Department obviously will take a very close look at the evidence that the Senate is providing to the FBI. Given the standard that you have personally demonstrated for recusal to avoid even the appearance of partiality, It seems clear to me, this is my opinion, that Mr. Mueller should recuse himself based on your standard here from investigating involving Russian collusion a long time ago. That's my perspective. I've suggested many times that the existing Russia-Trump investigation that Mr. Mueller is conducting is a snipe hunt. And as many of the members of this committee have indicated, however, there does seem to be damning evidence related to Russia and Hillary Clinton's State Department. If there had been as much evidence, in my judgment, against the president as we have against the Obama administration and Mrs. Clinton, I'm afraid Mr. Trump would have been burned at stake by now. There's a clear inequity. The FBI and the Department of Energy court documents detail an extensive, coordinated scheme of kickbacks, bribery, extortion threats, and general wrongdoing related to the acquisition of an American uranium trucking firm and the Canadian mining company Uranium One by the Russian nuclear giant Rosatom. The FBI investigation obtained an eyewitness account backed by documents indicating Russian nuclear officials routing millions of dollars to the U.S., which benefited the Clinton administration, or Clinton Foundation, the Clinton Foundation. Despite this evidence, rather than bring charges in 2010, that was not on your watch, the FBI continued the investigation for 4 more years and allowed the acquisition of 20% of our strategic uranium supply to take place without informing Congress. The head of the FBI at that time was Robert Mueller. So, General Sessions, I guess my question is really sort of just one for the record here. I think the committee is about to close up here. What do you think the Justice Department can do to correct this seeming lack of or reversal of priority here and what appears to be to some to be an injustice? How can we just look at the evidence and the facts for what they are and do what appears to be the right thing?
Well, you raised a question that we have much going on in the Department of Justice. Yesterday, I sent, I believe, to you and to the chairman, 15 or more members of this committee, a response to a request that you made some time ago, that we're going to bring in independent prosecutors to review a host of matters out there so I can look you in the eye and tell you that we've done the right thing and we've done an objective evaluation of matters that have been raised by this committee. And hopefully we can decide if there's some matters that need to be investigated. Some may need to be closed, some need to be open, some may need more money and resources and agents. So I feel like that's my responsibility. I don't believe that is a giving in to politics. I believe that I should evaluate your request on the merits, and you raise some matters that I think I'm duty-bound to respond to.
Well, General Sessions, I'll just put it like this, that sounds pretty good to me. And I appreciate you appearing for the committee today. Are there other, we have other, I'm sorry.
Well, I don't have a question.
After the battle's over, they always show up for dinner, you know.
I just was going to ask unanimous consent, since there's been all this stir about senators meeting or not meeting with Russians. I would ask unanimous consent to have this part of the record. It is an article from March 3rd, 2017 by Katie Pavlich. It's a list of Democrats who also met with the Russian ambassador, and then also this article from June 26 regarding Senator McCaskill's tweet that she got no call or meeting with Russian ambassador ever. And then it turns out, the article points out, actually she met with the Russian ambassador at his home, and I would like those in the record.
Without objection. And now the gentleman from Georgia is recognized for 5 minutes. So sorry you snuck up on me there.
No, thank you, Mr. Chairman. I've been in that other little thing we got going on, tax reform, getting ready to do that tonight. Attorney General Sessions and Mary, thank you for being here. And now I will say I'm from Georgia. There was something that was said earlier in this hearing that I was going to just pass by, was going to let it go.
Yeah, that's right.
But that sound of fingernails on a chalkboard, especially this week, when I heard War Eagle. Congratulations, y'all did well, and
we didn't. But I think the biggest thing is one, I want to thank you for coming. I want to thank you for answering. I've listened to your questions. I've listened to the answers. I appreciate your honesty, even if we disagree, because I have sat here before and talked to previous attorney generals that I couldn't even get them to admit that 65 law. You would agree that is against the law, correct?
It is against the law.
There we go. We're far ahead of where we were last time. But I do have an interesting issue, and it's a bipartisan, because I believe that this committee actually works, and I do believe your work in the Senate shows that we can come together and there's compromise. One of the areas that's very important to this committee, but it's very important to our chairman, but also bipartisan important to me, is criminal justice reform. One of the problems we always have, though, is we seem to gravitate toward the sticking points instead of finding areas where we can work together. Wouldn't you say that an approach in which we can start finding solutions would help us get to those points maybe where we have sticking points? Do you think that would be a good thing?
Yes, I think there are things that definitely are doable that we all could agree need to be fixed.
Well, I think so, and I've worked across the aisles on this. We've worked from a very conservative to a very liberal perspective. It doesn't matter, because at the end of the day, I believe that those in our system are valued human beings by the gift of God that's given to each. They've made mistakes. They're paying for those mistakes many times. It's a money and moral issue. Are we doing what we can to redeem the folks who are in there and actually give them a chance, if they choose to have a better life as they get out? We have a bill called the Redemption Act, and it's bipartisan. We've been working on this. It's something that is for basically taking those, once they get into the federal system, starting them early, and making sure that they have a path toward getting back out and having lowering their recidivism rate. What we've run into, though, and we've talked to the White House about this, and there seems to be always this knee-jerk, well, we'll just package it together with a bigger bill. I believe, and I would love to get your work on this, that if we could work with the Bureau of Prisons to start this one bill, this simple bill that doesn't deal with the sentencing, it just gives them time to get time off, transition earlier to work release, to give them settable, obtainable goals that is about accountability and responsibility, so that when they come out, the recidivism rate is lower because they have marketable skills and things that we can do. What I'd like to know is, do you think that if we could work that in the House and the Senate, get that to the President, who has been supportive of this and his administration, do you believe that is a workable solution? Given your time in the Senate, we get so stuck on things we can't do. Wouldn't it be good if we start on something we could do?
I believe a pre-release program can be effective. Most of the time, according to my experience, they don't achieve huge results, but if they achieve 10, 15, 20% improvement, that's of value. What I have learned, and perhaps you'd like to examine it, the Inspector General at the Department of Justice has done a review of pre-release programs and found some of them are not very effective, some of them are effective, and not enough attention has been put on it, and maybe the money could be better and more effectively spent. And we got a new prison commissioner, Bureau of Prisons. He's open to this. We've talked about it. So I'm hopeful that we can improve that. And fundamentally, we do need to make sure that anything that's done with regard to these reentry programs, that we've studied the best ones and try to make sure our money is going to the better programs as opposed to some that may not be as efficient.
Well, thank you for the rousing endorsement of the bill, because that's exactly what it does. It gets the people from the minute they start in, so that the Bureau of Prisons evaluates them and puts them on a plan while they're still in prison. We're not talking about, this getting them out quick. We're saying here's why they're at serving their sentence and earning that time up to where they're able to then have skills and skill sets so that when they do leave, the recidivism rate's down. It's based on evidence-based approach. We're not saying just put them out because we're soft on crime or not soft on crime. This is evidence-based approach that we've seen work in places like Georgia, Texas, Kentucky, all over the place, conservative states that have said, this is something we need to do. I appreciate your commitment to law and order. And my father's a Georgia State Trooper. He was 31 years. Believe me, I fought the law every day and lost. But he's still my dad, and I understand law enforcement's role, but I also understand after we get there, after they pay that crime, what can we do as a society to make sure our money is well spent, and also actually look into these folks' eyes and say, we're going to give you a chance, but it's up to you. And I appreciate your discussion on that. I want to see that move forward. It's something I think we can move forward both in the House and the Senate, and gives the President and the Department of Justice something to build on as we get to the tougher issues of sentencing reform and mandatory minimums and those kind of things that we know always bog us down. I appreciate you being here today, the President, and what y'all are working on has been appreciated, and it is always good to see Mary as well. So thank you for being here. Thank you. Thanks much. And Chairman, I yield back.
Thank you very much. I want to thank the gentleman from Georgia for ending on a high note. And I will say that General Sessions, Mr. Conyers and I both look forward to working with you and others in the administration on criminal justice reform. I think you'll find the approach here will be very bipartisan, perhaps in contrast to some of the other issues that have come up here today. But I also want to say to you, thank you for your time. Thank you for the careful manner in which you have listened to questions and concerns here on this committee for the better part of 5.5 hours. And I truly believe that this has been a very, very good hearing. Some of the members asked you questions for which answers have already been provided. Apparently they've forgotten that those questions were asked and answered previously, but you've answered all of our questions here today in what I think is a manner that befits you as the Attorney General of the United States. I thank you very much for that. And with that, I want to thank you, and I want to thank all the members for participating. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record, and the hearing is adjourned.
Amen.
And that wraps up the hearing, the House Judiciary Committee hearing with oversight of the Department of Justice, and quite a day it has been. Among the headlines, the Attorney General Jeff Sessions wrapping up his testimony in Capitol Hill, and the Attorney General says the accusation that he lied under oath is a lie.